Model Rule 3.8, sections G and H, are about a prosecutor's duty to remedy wrongful convictions. Model Rule 3.8, G and H are the last two sections of this very long rule. Section G says, when a prosecutor knows of new, credible, and material evidence, creating a reasonable likelihood that a convicted defendant did not commit an offense of which the defendant was convicted, the prosecutor shall, it goes on and breaks it into several parts. 1, promptly disclose that evidence to an appropriate court or authority, and if the conviction was obtained in the prosecutor's jurisdiction, promptly disclose that evidence to the defendant unless a court authorizes delay, and 2, if the conviction was obtained in the prosecutor's jurisdiction, has to undertake further investigation or make reasonable efforts to cause an investigation to determine whether the defendant was in fact convicted of an offense that the defendant did not commit. So that's a lot all at once. Let's unpack it a little bit. Notice for test purposes the distinction between the prosecutor's own jurisdiction and everywhere else. A few years ago, there was a case where the police arrested a murder suspect, but during their interrogation or questioning, the suspect confessed to being a serial killer and confessed to several murders in different states over the years. Some of these murders were old cases where someone else had been convicted and was actually serving a prison sentence for that crime, even though they had always claimed their innocence. So this is an example where a prosecutor may learn that cases in other jurisdictions may have resulted in wrongful convictions. Now, it's always possible the person is making it up, right? That the person who's been arrested just wants to be famous and is claiming to be a serial killer. But if this happens, the prosecutor has to at least notify the court in that jurisdiction. But honestly, a prosecutor has limited power to do much to reopen a case, let's say, in another jurisdiction. But if it's in the prosecutor's home state, there is more that a prosecutor can do, and therefore there's more responsibility. In his own state, a prosecutor can launch an investigation to get to the bottom of it, and can easily notify the defendant so that the defendant can try to undertake some investigation as well, and that's what this rule requires. Rule 3.8 continues, and this is the last section. In H, when a prosecutor knows of clear and convincing evidence that is establishing that a defendant in the prosecutor's jurisdiction was convicted of an offense that the defendant did not commit, the prosecutor shall seek to remedy the conviction. Students should pay careful attention to the difference in the level of evidence between sections G and H. Under G, it's new and credible evidence, even though it might not be entirely conclusive. But that would be enough at least to warrant further investigation by the prosecutor and disclosure to the defendant if it's in the prosecutor's home state, or notification of the relevant court if it's in another state. But section H is for the scenario where that investigation yields very strong evidence, clear and convincing evidence of the defendant's innocence. And note, this is a little less than beyond a reasonable doubt that's required for a conviction. So now, in this case, the prosecutor must start the process of remedying the conviction so that the defendant will get out of prison if the defendant is still there. So what are the next steps a prosecutor should take under, let's say, section H? Well, even under section G, we're going to start with disclosure of the evidence itself to the defendant. So you're not just going to tell the defendant, hey, there is some evidence. You're going to tell them what it is or turn over the evidence. And if it's clear and convincing, you're going to request that the court maybe appoint counsel if the defendant is indigent and is unrepresented. Notifying the court that the prosecutor has knowledge that the defendant did not in fact commit the offense for which they are serving a sentence. We should pause for a moment here to talk about something called release dismissal agreements. In many states, someone who turns out to have been wrongfully convicted and imprisoned sometimes they've been in prison for years or decades, may be able to sue for money damages when they're released. Some states have a set amount in their statutes, and others leave it open so it can be decided on a case-by-case basis. So a prosecutor's agreement to dismiss the criminal charges in exchange for the defendant's release of any civil claims arising out of the arrest is called a release dismissal agreement. In other words, the prosecutor is asking the defendant to agree not to sue the state for their wrongful conviction and the years they spent in prison if the prosecutor will help them get out of jail faster. Federal courts have actually held that release dismissal agreements are valid and enforceable as long as they're voluntary and there's no evidence of prosecutorial misconduct. So the prosecutor can't make one of these if the prosecutor himself or herself engaged in misconduct, and if enforcement would not adversely affect the public interest. The U.S. Supreme Court decided this in Town of Newton versus Roomery in 1987. I think that this is terrible, and I hope that my students someday are in a position to change this. I want to make a quick mention of a recent ABA ethics opinion about plea bargains for misdemeanor offenses. And here I'm talking about ABA Formal Opinion 486. It explains that the model rules impose some obligations on prosecutors when entering into plea bargains with those who are accused of misdemeanors. And that includes, and they list them, number one, ensuring that each charge incident to a plea has an adequate foundation in fact and law. Number two, to ensure that the accused is informed of their right to counsel and the procedure for securing counsel. Three, prosecutors should avoid plea negotiations that jeopardize the accused's ability to secure counsel. And four, avoid offering pleas on terms that knowingly misrepresent the consequence of acceptance or otherwise pressure or improperly induce acceptance on the part of the accused, irrespective of whether the unrepresented accused has invoked his right to counsel. Now, why did the ABA put out this ethics opinion? Well, they were concerned that prosecutors were basically ignoring their duties under Rule 3.8 in misdemeanor cases, because nearly all of them resolve in plea bargains quickly. Prosecutors may view a lot of these cases as minor cases or even a nuisance, and they want to focus on their big felony trials. So they might tell themselves that if a person is facing no jail time, let's say, and a lot of plea deals involve probation or fines or community service, or at most some token jail time of a few days or weeks, so maybe they think that they don't have to worry about protecting the defendant's rights as much. Well, the American Bar Association says they do. Even if the plea bargain results in just a fine or probation, the conviction can have far-reaching legal consequences for things like immigration status or child custody or employment or gun ownership, and their sentencing as a repeat offender if they face criminal charges sometime in the future. I haven't seen many cases, or any cases yet, of prosecutors being disciplined under these specific guidelines for misdemeanor cases. But for purposes of the MPRE test questions, students should be aware of this, that all of the rules here apply even in a misdemeanor case, even if it's not a felony conviction, even if there's no jail time on the table. And that concludes our discussion of Model Rule 3.8.